my name is Deb Mahaffey, and I am a child custody attorney in Harrisburg, Pennsylvania with Hynum Law. And I'm going to talk to you about what to do in your child custody case if you have concerns about the other parent that might have some mental health issues in their background. A lot of times people will tell me that the other parent is bipolar or has some type of mental health problem, was in a psychiatric facility, takes some type of medication, has anxiety, depression, those types of things. I hear that almost every day. And those are legitimate concerns if there really is a serious mental health issue going on in the case. So if you have those kinds of concerns, I'm going to talk about what you can do in your child custody case to address them. Because the last thing you want is for your child to be in the custody of someone that has a severe mental health problem. Our courts focus on the best interest of the child, and we want to make sure that the children are always safe when they're with their parents. So if the other parent has some kind of mental health history that you think needs to be more carefully looked at before a custody order is entered, one of the things that you can do is you can request that the court order the other parent to undergo a psychological evaluation. And when you make that request, your attorney can simply ask the other attorney if that parent will do it. And if they'll agree, you can just go ahead and have it done. Or if they do not agree and they challenge that request, you'll need to file a petition with the court and ask a judge to order that party to undergo a psychological evaluation. But the Child Custody Act does authorize the courts to order a parent to do this if there's a reasonable basis and the judge thinks there's enough there to order the evaluation to be done. Sometimes people ask me about their mental health records and whether or not they are subject to disclosure in a child custody case. And the answer is it all depends. If a party has been hospitalized, for example, inpatient treatment, it is very difficult, if not impossible, to get those records because we have all kinds of laws, not only state but federal laws, that protect mental health records. If you go to outpatient counseling, just go see a therapist of some sort, generally all of those communications are going to be confidential and are going to be protected, but there are, again, exceptions. For example, if you say to your therapist, I'm thinking about hurting my child, that therapist is what's called a mandated reporter and will have to make a report to Children Youth Services, so therefore would have to violate confidentiality essentially and make that report. But generally speaking, your communications with your therapist are privileged and cannot be disclosed in child custody cases. Where it gets a little tricky is if a mental health evaluation is ordered, the evaluator would be given authorization to talk to your prior therapist, look at your prior psychological and psychiatric records, and perhaps that information might be in the mental health report that comes out in the custody case. So these are all very complicated issues, and it's very important that you work with an experienced child custody attorney if you have these concerns about the other parent and you want to get records or try to get them, or if you're the parent being accused of having a mental health problem and there's certain things that you don't want out there, that you want protected. And you need an attorney who knows these confidentiality rules that get very tricky and very complex. So if you have any questions on this topic, please feel free to give me a call at 774-1357 or go out to our website at www.hynumlaw.com and schedule a consultation with me.